computer. There we go. Hi, greetings. Welcome back for another commercial conflict resolution session on YouTube and CPR Speaks, the blog of the International Institute for Conflict Prevention and Resolution. I'm Russ Bleemer. I edit alternatives to the high cost of litigation for the CPR Institute, which you can find at altnewsletter.com. We've reconvened two familiar faces here and a new guest to discuss Tuesday's U.S. Supreme Court argument in Henry Schein versus Archer and White Sales, Inc. We have a link in the CPR Speaks version to the case. So far, it's the only arbitration case the nation's top court has thus far agreed to hear in the 2020-2021 term that began online last month. But there's a sense of deja vu here for me and my guests today. Unlike most of those weird senses, this one's 100% legit. The court just decided this case last year. Very briefly, in January 2019, Archer and White Sales, like this year, was the respondent. It had filed suit against petitioner Henry Schein, alleging violations of federal and state antitrust law and seeking both money damages and injunctive relief. The contract for their medical equipment sales agreement provided for arbitration of any dispute arising, with some exceptions, one of which was for action seeking injunctive relief. So Henry Schein asked the U.S. District Court to refer the matter to arbitration under the Federal Arbitration Act, the FAA, but Archer and White said that its complaint sought injunctive relief in part. So the question became whether the matter should be arbitrated. Schein said that the arbitrators have the power to resolve arbitrability questions, that is, questions of whether the arbitration agreement applied. Archer and White countered that Schein's argument for arbitration was wholly groundless because of the contract's carve-out for injunctions, so the federal district court could resolve the threshold arbitrability questions. The district court in the Fifth Circuit agreed with Archer and White, and in January 2019, the Supreme Court reversed and said that the idea that the argument was that accepting the case from an arbitrator was wholly groundless was inconsistent with the FAA. And in a unanimous opinion by Associate Justice Brett Kavanaugh, that, by the way, was the then new justice's first Supreme Court opinion in January 2019. In that opinion, the court, while striking the wholly groundless exception, remanded the case with instruction to the Fifth Circuit to investigate, quote, whether the contract at issue delegated the arbitrability question to the arbitrator. The standard that they had to look at it under was whether the parties agreed to arbitrate arbitrability, and the evidence was by clear and unmistakable evidence that they did so, okay? The case resumed in the Fifth Circuit and was back before the court after about a year, and that brings us to the case that we're talking about today. This time it's about that remand. Specifically, the issue we're talking about here is, quote, from the court, whether a provision in an arbitration agreement that exempts certain claims from arbitration negates an otherwise clear and unmistakable delegation of questions of arbitrability to an arbitrator. The Fifth Circuit found that the clause in the contract between Schein and Archer and White had delegated arbitration to the arbitrator via incorporation of American Arbitration Association rules to that effect. But the court said that the way the clause was drafted, that is the carve out for injunctions, had still applied, and it once again refused to enforce arbitration. So that's basically where we are today via Henry Schein's successful cert petition. That delegation clause sparked interest and was also one of two other points in the decision that were the subject of a cross petition by Archer and White. That was rejected by the court. I won't go over those now. I'll leave it there for a moment. It'll probably come up in our discussion. We're joined by Dallas arbitrator Richard Faulkner and New York arbitrator Philip J. Lurie Jr. They returned to lend order and expertise to this, but they're back here on our blog in a different posture. Following up on their strong views in this forum earlier this year, they went in on an amicus brief, which we will link to on the CPR Speaks blog, and they're going to justify that and explain it to us in a moment. But I want to start with a newcomer. Welcome, Professor Angela Downs. Professor Downs is a professor of practice and assistant director of experiential education at the University of North Texas, University of North Texas, Dallas College of Law. She's in Dallas. Professor Downs, you follow these arbitration matters all the time. Can you tell our viewers, can you tell the legal community why this one should matter to all of us?
Oh, absolutely. And thank you, Russ, Philip, and Richard, for this kind invitation to join you to talk about this very important case. I also am a very proud arbitrator and mediator. Um, but what is so important about this case um, is because as I look at this through the lens of a practitioner, as well as a law professor, I see two things that strike me. Um, and one of the most important things that I see that is derived from the Schein case and the decision is the demonstration of really the importance of careful drafting. Because, but for the drafting of this contract between these two parties and the ambiguous language that they are bringing forth for interpretation from the courts, we wouldn't be here. So as I look at this case from the lens as a law professor who's teaching the next generation of law students, this is a clear example of the importance that words matter. You know, when we say words matter, sometimes people don't really take it seriously. But certainly, if you look under the layers of this case, and it seems as though it's like an onion, you keep peeling back layers, and there are things that come forth as you continue to investigate. The wording of that arbitration clause in this case um, has really created a problem that is not so readily solved, and we're still going through to try to make some sense of. Um, so I look at it from that sense, from the law professor perspective. And as a practitioner, I think it's critically important for mediators because it's really shaping the role that mediators and arbitrators will have. Because even though the case is not talking about mediation, there's still some trickle down to the mediation world. But if we focus on the importance that this case will lend to how arbitration is seen, how it is looked at as part of contracts, I think that this, you know, the end result on this case could really shape and really change the nature of arbitration for years to come.
That's great, Professor Knowles. Thank you. It seemed like the Fifth Circuit opinion, the one on appeal now, was a CLE class in arbitration clause drafting. We've had those. You see them all the time, but they put a new spin on it. And for now, it seems like that's going to keep the professors quite busy for sure. And we'll be hearing a lot about that. Did Phil, in your amicus brief, please tell us about the amicus brief and who you filed it on behalf and how it affects the case? Did you talk about the drafting in it at all?
We did, and I must say that I agree 100% with Professor Downs's analysis of this case. It does come down to drafting, poor drafting versus not good drafting. And had there been, and we went through this in a previous show. I mean, you're dealing with a one-sentence arbitration agreement, which could have been divided into maybe 2 or 3 sentences, and there would be no basis for being here. Well, just to back up for a second, the brief is entitled "The Brief of Arbitrators, Arbitration Practitioners, and Arbitration Scholars" as amici curiae in support of Archer and White Sales Inc., the respondent. And the counsel of record was or is, I should say, Professor Imre Stephen Solly, who is the Judge John D. Wessel Distinguished Professor of Social Justice at Loyola University, New Orleans College of Law. And it's a shame that he's not here today with us because he was fantastic to work with, and he took the initial draft of this, got it going, and then Rick and I worked with him, and we got input from the other practitioners and professors who joined in, and of course, Professor Downs was one of those professors, and there are some others too, but we're so and we did it basically to highlight an issue in the case, which is the incorporation by reference issue, whether you can get a clear and unambiguous delegation of a delegation agreement. In other words, an agreement under which the parties agree to arbitrate arbitrability issues. Whether you can do that.
Just to be clear on that, Phil, that
Yes.
was one of the two issues that I had mentioned before that Archer and White cross-petitioned the court on, and the court declined to hear here. However, it wound up back in the Archer and White brief to the Supreme Court now. So you're urging it as well in your brief. What do you think the odds are of it coming up in an oral argument next week?
Oh, I think it will definitely come up in oral argument. And if you read the Archer and White's brief, they did focus on this argument a lot, and it's a premise for the question presented as to whether, I mean, if there was no clear and unmistakable delegation here, then it makes no sense to consider whether the carve out basically negated an otherwise existing delegation agreement. But let me, and then the other side in the case of petitioners, it's obviously they're making that, trying to avoid the court from taking this argument. They're clearly, I was reading the reply, they're clearly not happy with it. There are basically 6 points in the brief. The first point was just pointed out that there's no agreement here actually between Archer and White and Schein, because they're horizontal competitors, and the arbitration agreement here is a bit with the vertical supplier of Archer and White, and the other party is seeking to arbitrate based on equitable estoppel grounds. Now, you won't hear anything about that, but we got into that nevertheless because it's one of the reasons, or it's further evidence that there really is no clear and unmistakable commitment to arbitrate arbitrability. I mean, you shouldn't have, at the very least, there should be an actual agreement between the parties as opposed to one party claiming under the agreement on some equitable basis. Point two, we point out that the incorporation in this case, which was basically that the parties agreed to arbitrate in accordance with the arbitration rules of the AAA. Well, there are many, many arbitration rules that the AAA has in its website. We get into reasons why someone confronted with that language wouldn't really even begin to think that you were necessarily incorporating by reference a delegation agreement. Now, point three was really I think it's the textual analysis of the arbitration agreement and why the language used doesn't necessarily clearly, it doesn't necessarily incorporate by reference a delegation agreement contained in the AAA commercial rules. And we get into the details of that, and basically we make two arguments, but the key argument was that to arbitrate in accordance with AAA rules can be reasonably interpreted to mean that the parties agreed to arbitrate in accordance with the AAA rules governing arbitration procedure and arbitrator selection, arbitrator qualification, and the like. Basically, the ground rules of the arbitration. And this goes back to a point that Professor Downs was making. You're right. There's a lot of people. Everybody's got a different spin, essentially, on what this agreement means, and that actually helps Archer and White's position a lot, because you have no delegation agreement unless it's clearly and unmistakably agreed to. And as Angela points out, there are reasonable interpretations all over the place where you would find that the parties did not necessarily agree to arbitrate arbitrability. Point four, we talk about the agreement being a moving target, because by their very nature, the AAA rules are subject to being changed or modified at any time. And in point five, we point out that in these delegation agreement cases, there is an inherent conflict of interest. An arbitrator who sits both to hear an arbitrability dispute and the merits of a case, and who gets paid by the hour, has an economic interest in the outcome. In other words, if the arbitrator rules that the dispute is arbitrable, there's going to be more proceedings and more fees. That also applies to the arbitration association as well, because they're going to get more fees as well if the case is goes on for longer, involves more money and the like. And so that we address that in point 5, and in point 6 we kind of tie everything together and we say we urge the court to either rule that in cases like this that there has to be an express delegation agreement set forth in the contract itself. And that would, then there would be, as Angela pointed out, no, we wouldn't be here. And as an alternative to that, and we put this in because we wonder if the court's really going to adopt that kind of a bright line rule, is that there should be, that the court should find there is no delegation here, and emphasize that the lower courts exercise great care when applying the clear and unmistakable rule. And that's consistent with the first options decision, and how this is an arcane issue, and we got to be careful not to be forcing people into agreement. It's a federal law issue. That's important to remember, and that's a key point. And I certainly hope that the court reaches the issue and affirms the Fifth Circuit, but issues an opinion explaining why.
Phil, that's a great rundown. I really appreciate it. Really enjoyed going through all of that. I wanted to point out,
I'm sure you did.
one of the points that you made about equitable estoppel. That was the other issue, along with the effectiveness of the delegation that was proposed by Archer and White for the court to review, and the court rejected that. These were both rejected on June 15th, the same day when the court took the issue that's before us now. So, Rick, how do you square? Phil tied in all of many issues to the one discrete issue that we're facing now. Okay, again, that the issue that we have is the court giving you the court's particular wording is whether a provision in an arbitration agreement that exempts certain claims from arbitration negates an otherwise clear and unmistakable delegation of questions of arbitrability to an arbitrator. Kind of tying together what Phil said and what's in your brief is that all of these other issues, even though they're rejected, are still a part of it. How do you square the fact the Fifth Circuit, as I read it, seemed to indicate the delegation was just fine? Incorporating the AAA rules, whichever ones they were just fine. That's okay with us. Our problem, the way I read the Fifth Circuit, was it's where the commas are and the way this thing is constructed.
I think that the Fifth Circuit clearly had some problems, but one of the things I noted was that when the petitioner originally sought cert, it made all this parade of horribles about how if the Supreme Court didn't take the case, anti-arbitration courts were going to gut arbitration, and that ignored what is a real problem for the petitioner, which is the Chief District Judge who decided this case, Rodney Gilstrap, is himself a fully qualified, experienced international arbitrator. He is very much an arbitration scholar. So petitioner was blessed with someone who actually knew, understood, and could properly interpret these clauses. And sometimes that's a blessing and sometimes it's not. I think, each of the parties would have their own view as to whether it was a blessing or not. But this is not a hostile court. This is not a court trying to eliminate arbitration. What we do see is that we are now almost 9 years after this case began. The matter still has not yet been resolved. It has had 2 trips to the Fifth Circuit, 2 trips to the U.S. Supreme Court. God knows how much time in the magistrate, judge, and trial court with these issues being addressed. and we still don't have a decision. Now,
We've had to deal with the successor issue already as to who is the proper party here, who's the signatory, because there's been succession to the original contract.
exactly. And one of the things that we also needed to deal with was that, yes, as petitioner correctly points out, all the circuit courts of appeal have, in fact, just assumed that arbitrability could be incorporated by mere reference to association rules. The problem with that is when you go and look at all of those cases, it's very tautological reasoning. They cite each other and everybody assumes that somebody else did the hard intellectual lifting and work of analyzing these issues, and nobody really did. And so what you are faced with is a court now having this issue squarely before it. And on top of that, as we point out in the brief, there's yet another problem that no one has really raised before, but which raises constitutional issues, and that is the clear, unmistakable, unavoidable conflict of interest by the financial self-interest of these arbitrators and arbitration associations in determining arbitrability, to always find that disputes are arbitrable. Everybody's been kind of dancing on this point and saying, well, arbitrators are paid by the hour. Let's be clear. It's not just what they're paid per hour for determining arbitrability. It is the entirety of the arbitration case. And that means you're not talking about a few $1,000s. As I pointed out in a Fifth Circuit brief years ago, arbitrators frequently make $50,000 to $100,000 per case, sometimes substantially more than that. And so, as you know, we learned from some of our founding fathers, that is a real temptation that probably only the angels could resist. And we are not a government or a legal system of angels. So the courts need to be the ones intervening. You do not have courts touting in the hallowed halls of justice for new business. I can tell you, having been a trial judge, one, I could never hear any issue in which I had a financial interest, nor in which even a family member had a financial interest. But I also didn't lack the cases. Every trial judge has more cases than they need. The docket of the Eastern District of Texas is well known as the Rocket Docket. This case being an exemption because of the problems inherent in the poor drafting. Now, the drafting in this case is really bad, as everyone has pointed out, including the respondent. A single sentence, the arbitrator shall determine all issues of arbitrability, would have sufficed to have eliminated most of these issues, though not the one of arbitrator conflict of interest or association conflict of interest. And the case, the brief cites the seminal case, which is Jackson v. Rennes Center West, which I find personally interesting because I drafted that original language. I put delegation language in there specifically to prevent the Ninth Circuit Court of Appeals from trying to find a way out of my arbitration agreements. And it worked. Unfortunately, what we now have are rules that incorporate in boilerplate, hidden somewhere in the middle of nowhere in 50, 60, 80 pages of rules, one or two lines saying the arbitrators will have the competence to determine jurisdiction. Well, what does that mean to even the average lawyer, much less the average business person? One of the concerns we had in deciding to file an amicus brief was arbitration is not going to be used by small business or mid-sized business if it results in these kinds of legal equivalents to how many angels can dance on the head of a pin. We need the Supreme Court to make this determination, to make a decision on this. And it's more so because it is such a widespread issue. And remember, the state courts of appeal and state Supreme Courts are conflicted. You have a number of them that have done very careful analysis and found that mere reference to a set of arbitration rules is insufficient to meet the standard in Kaplan versus Chicago Board of Trade. And I think that's really important because, as has been pointed out in some of the briefing, other than people like the four of us sitting here, no other normal person looks at these arcane issues when they're deciding whether or not they're going to put an arbitration clause in a contract. Let's face it, y'all, these are midnight clauses. Everybody's ready to pop the champagne, go on and celebrate the new contract, and somebody says, oh, maybe we ought to have an arbitration clause.
Hey, Rick, that's a perfect intro to a question I was wondering. However this case is decided, how important is it to drafters to carve out injunctions, which is really at the core of what they're going to argue on Tuesday? People want control of that. They're afraid assets are going to be lost. They want to control those injunctions. How is this going to affect whether they put in a clause that carves out injunctions for the court or goes to another quote unquote neutral arbitrator to decide that, who's not involved in the case? Is that area of carve outs about to get a refresh in new scholarship and new advance?
This is extremely important in the areas of intellectual property, non-competition, non-solicitation agreements. California has very clear law on that as a matter of public policy. But for many of the other states, you actually have to run to the courts to get temporary restraining orders or preliminary or temporary injunctions in order to stop, violations of intellectual property law, theft of trade secrets, misuse of trade secrets by someone who leaves one employment and goes to another. I've arbitrated these issues. I've litigated these issues. This is a big, important issue. If this stays confused, I can see a lot of businesses saying, you know what, if I just go to court, I don't have to worry about all of this. And it doesn't cost me, $50,000 to go to an arbitration to find out whether or not I actually really agreed to arbitration or didn't. And that's a very important issue. And frankly, people don't necessarily realize the Eastern District of Texas is one of the most experienced and busiest intellectual property jurisdictions in America. At one time, I want to say 40 to 50% of all intellectual property cases in the federal courts in America were in the Eastern District of Texas. And now it's split between the Eastern and Northern districts of Texas. So this is an extremely important issue. And the safest thing for any business to do or lawyer to do who isn't an arbitration specialist is just say no arbitration.
Professor Downs, you're in that district. I want to ask the same question to Phil, who's here in New York with me. But Professor Downs, you're in that district. Regardless of what happens on Tuesday, what do you tell clients who come in now and ask about that provision? How do you tell them to handle it? Is it okay if the arbitrators decide whether or not there should be a preliminary injunction?
I think building on what Rick has just shared about the, this case really is a big deal. And it's important for, intellectual property practitioners have they're sitting up and taking notice because, they commonly, have arbitration clauses, but they usually expressly exclude certain types of disputes from arbitration. Things that are looking at validity, scope, infringement, and essentially things that are in that patent claim. They're keeping those things out. So I think it's really important for all practitioners and for companies that are coming to work with lawyers for arbitration clauses to really look at seeking that injunctive relief from the courts. Because I think right now this issue just has not been settled, and to ensure that they have that option there, I think might be a way to protect themselves.
Let me add one.
That's great. Phil, does it look the
Russ,
same?
And that is, having been a state judge, the only binding authority on us is the U.S. Supreme Court and our own state Supreme Courts. And quite frankly, quite often, it's nice what the federal appellate courts have held, but it's not binding authority. It's persuasive, and that's it. Mm-hmm. And frankly, where there has not been a rigorous intellectual analysis, which is certainly the case in this area, then frequently trial judges in the state courts disregard the unanimity of these federal courts of appeal because they just assumed that this met the Kaplan test.
Mhm.
That's great, Rick. I appreciate that. Phil, your reaction to that, and the same question for Professor Downs. What are you telling clients now this week about the carve-outs and the injunctions and about who's going to decide arbitrability?
Carve-outs are important, certainly important in IP cases, but they're just as important in employment cases where you might have
Yes.
an employee who runs out and
Definitely.
with trade secrets or whatever, and of course the problem is you can get an injunction in arbitration, but it's enforcing it. You know how it is here in state Supreme Court in New York. You run in and a couple of days notice, get an order to show cause, and you can stop somebody from doing whatever it is you want to stop them from. But my advice would be make it, it's to avoid this issue. And again, the way to avoid it is you deal with scope in one part, and then if you really want to have a delegation provision in the contract, put it in the contract. If you're going to incorporate the AAA rules, but you don't want to incorporate certain rules, then be specific about that. And then you hope for the best. But it's amazing that a lot of people don't seem to go through those steps, and that's why you have these wasteful disputes, which may be intellectually interesting for people like us. But apart from that, they're not the greatest thing for the court system.
Well,
Thanks, Phil. I was going to say we're running short on time. I was going to ask Phil to keep it going if he has any outlooks or any predictions for Tuesday, and then we can go around the room.
Yeah, I would. This case could go either way, and I mean that. I really have given a lot of thought to this, and I can articulate arguments, mostly technical legal arguments, using the concepts of separability, Renter Center versus Jackson, and that sort of thing, to say, well, look, if somebody incorporates by reference the rules, then you got to look at this as a separate antecedent agreement and forget about everything else. And that's basically what the other side is saying in this case. But we get back to common. One thing about this case is that because it's one sentence, it really forces you to look at how important drafting is, and hopefully the court enough people on the court will say, look, we shouldn't be rewarding poor drafting by, letting people use esoteric legal theories to justify arbitration of arbitrability. We should go back to the common sense approach that we saw in first options, and using those principles, come to the right decision. I think the right decision is that you have to look at every incorporation by reference case as on its merits, and so it's a drafting thing, and we should be encouraging clear drafting.
Thanks, Phil. I stepped on Professor Downs's comment, so if you could hold that for a minute, we'll follow. We'll give you the last word, but let's let Rick follow. Well, let's let Rick follow up with his view for Tuesday. And his predictions, since again they have skin in the game now, they're a part of it. Tell us what you think is going to happen, and if you want to follow on, is this still going to be a delegation case?
My prediction is that with the vast amount of briefing addressing these issues, and now the court knows the importance of these issues, and specifically the delegation issue, I think counsel are going to get a lot of questions about whether or not this is a proper delegation, whether there is any delegation at all, whether delegation by reference is permissible, or what should be done. I'm sure there'll be some castigation over the less than astute drafting by some of the justices in the questions. And I think that at the end of the day, the court's going to be tempted to decide that Kaplan was right, that the necessity for dealing with this arcane issue requires all of the parties and the lawyers to know and fully understand and agree to giving the issue of arbitrability to arbitrators. and even recognize that, wait a second, there is a real serious constitutional issue with the conflict of interest, and that maybe, the courts really are the only place where this should be heard. And it's going to provide for a real interesting exchange between the Supreme Court justices, because Chief Justice Roberts is himself a very expert drafter of arbitration provisions. And so he's certainly going to understand what proper drafting is and should be. So it's a bonus for everybody. It gives IP lawyers and employment lawyers guidance. It gives state courts guidance. It gives law professors and practitioners a lot of guidance. It's going to be a great case.
We should add at that point, if I remember correctly, Justice Roberts was the attorney on the winning side in first options when he was in practice.
He was in the losing side.
The losing side, first options.
I met the guy who was the attorney on the winning side. He was involved in the case I was in.
Well,
he had a lot of questions, and they were very pointed about arbitration.
Oh, wow.
They all may owe you a big thanks for getting this issue out, and Archer and White as well. If they do talk about delegation, I'll predict it at some point. Justice Roberts says, let's get back to the clause here. Let's talk about that. Professor Downs, if you would like the last word. I'm sorry, you were about to react to something Rick had said before the prediction, so fire away and we'll wrap up with you.
No, I think that I just think that this is definitely, as we've said, this is one to watch from so many different areas for the practice of law. And I think it's really going to come back to basics. I think it's, I'm feel as though I'm, remiss to make a prediction for the Supremes. But I think that they're going to want all parties at the table. They're going to want to look at what were the intents, what were the parties, what were they intending to do with this clause, and there's just not enough there. So I think that they're going to send it back to the courts and let the courts actually decide. I don't know that they're, that they're going to do anything, that's going to be too earth-shattering, because I think that it's such a poor draft, an example of poor drafting, that I just don't see that they'll really want to weigh in on that. But I think this case, it really comes down to drafting. It comes down to getting back to basics, and it's such a warning to all of us as practitioners about the wording of those arbitration clauses, and also focusing on any carve-outs, that both the arbitration clauses and the carve-outs, they just have to be so carefully drafted in order to avoid these unnecessary disputes and these unintended consequences, because we have spent 9+ years and I feel as though we haven't really made much movement. It keeps getting punted back and forth with the hope that Tuesday we'll get some kind of resolution. But I can say that as a law professor, I'm certainly going to be waiting with bated breath to see if we do reach something that's going to be a workable solution. So,
thanks so much. I love ending with a warning. Angela, Rick, and Phil, I really appreciate it. The links to them are here on YouTube to the CPR Speaks blog, and CPR Speaks blog has links to them as well. Thank you all for joining us. We really appreciate the analysis, and hopefully we'll get together and talk about this opinion in 2021.
Thank you, Russ. Absolutely. Thank you, Angela, and thank you, Rick.
thank you. This was
Bye-bye.
Awfully nice to meet you.
Nice to meet you.